I see that it's not on record. I may be called for.
Wait, with your lordship.
Yes.
My lord, this is my lord, only item 23 I am seeking for withdrawal, my lord. There are certain inherent defects, my lord, with a liberty
With
to
what
file
was this
express.
case?
My lord, in this matter, my lord, from the petitioner side,
Hmm.
there are 12 petitioners.
Ah.
6 petitioners, they have filed, my lord, a withdrawal petition without even informing the other writ petitioners, my lord. And that too with certain allegations, imputations on the other writ petitioners. That is why, my lord, I filed this review petition, my lord. 23, my lord.
Where is the order you are seeking review? Which page?
Fifty-six, my lord.
Huh?
56 page number. Front, in the front, my lord, certified copy has been, my lord, given in the front,
Order dated 6/3/24,
my lord,
6/3.
my lordship. 60. Front page of assessment. My lord, there are certain defects in the writ petition with regard to the.
No, tell
petitioner
me
side.
this 4, 5, 6, 7, 10 and 12.
My lordship,
They withdrew.
withdraw, my lord.
Remittance there. Then what kind of review? You are seeking review of this order.
This order, my lord,
On
because
behalf of whom?
other writ petitioners, my lord. Other writ petitioners, my lord, that, my lord, no, I filed a
No, writ
objection, my lord.
petition is not withdrawn accordingly. So far relating to 4, 5, 6, 7, 10 and 12.
They withdraw, my lord, with my lord, putting certain imputations upon the other writ petitioners, my lord. I filed an objection, my lord.
Oh.
On that particular day, my lord, I could not attend. That is why, my lord, this particular facts was never placed before this honorable court that there was an objection, my lord. And they have never taken any permission or neither intimated the other writ petitioners.
Now
with regard to that, my
what
lord.
do you want today?
My lord, only item 23, my lord, there are certain inherent defects, my lord, with a liberty
Item
to file.
23. What is that item 23?
23, my lord, the review, my lord, there are 6 number of writ petitioners, my lord, 2 writ petitioners filed an IA seeking withdrawal for
So you want to withdraw the review.
the liberty to file afresh, my lord, correctly, my lord. Otherwise, I have to file an IA, my lord.
What is the defect?
My lord, wrongly, my lord, the name of my lord, the writ petitioner has been wrongly written, my lord. That is why 3 numbers. My lord.
Okay, Mr. M.K. Das, only write in item number 23. Mr. M.K. Das, learned counsel for the review petitioners, submits that he may be granted to withdraw the present review petition and to file a fresh review petition by correcting the defects.
My lord.
Full stop. Prayer is not objected. Accordingly, same stance allowed. Same stance allowed. Accordingly, this petition stands dismissed on withdrawal with a liberty as prayed for. That's all.
Item 23, others will remain.
Others will remain. 24, 25,
26 will
26. What about 26 review?
26 correct.
26 is
Correct.
correct. Okay.
Deeply appreciated. Highly appreciated.
Okay. Others are apne likhiba. Anything to be ordered to be passed? Huh? No.
Because these were tagged, that
Okay.
is why it has come up.
Ultimately, again it will
Yes,
come.
yes,
Again
yes,
it will
yes,
come.
yes, my lord. I'm deeply obliged.
Deeply appreciated.
Mr. Bhattacharya, just before you start, is the issue what you have raised here not been answered by this Vijay Mandala case? that violation of
this-
Article 20.
This has to be tested in the touchstone of the Article 20.
No, that is what, that was a issue in Vijay Mandala specifically, whether this provision, this is compelling to disclose evidence against them, was a specific issue. I think that discussion starts at 150 by the Constitution bench, and it has been answered. So far, subject to what you argue, that has been said that it will not be a violation. And because at this stage, this is not an evidence and this cannot be used against that person. So this has been answered. So can we be on specifically this point? Specifically answered. The challenge to the act, and this was a specific challenge on that ground. What
Article 23.
yes,
Ma'am.
please. What has been asked by you was a specific point because the act was challenged on this point. This provision was also challenged. That has been answered from, I think, paragraph 152, 150 to 172. I think that,
Suppose, my lord, Article 20 is not applicable.
Hmm.
Otherwise, principles of the criminal jurisprudence, whether it is allowed.
the difficulty is this has already been discussed in details from 152 to 172. A specific issue. Yes, Mr. Junior Bhattacharya. I'm giving you the paragraphs. That is what. So otherwise, if you can, Mr. Bhattacharya, you can place it in a different way. I think you brief him properly on this point. See, give the file. I think it will start from
Section 50 of the
paragraph 150. You just quoted paragraph, rest of the judgment may not be necessary. It's a 200 something paragraph judgment. Paragraph 150, it starts and it is up to 173. And more particularly relevant provision will be around 1. Around it will be 159. This is what is this?
Vijay
This
Madanlal
is
Sundari.
2010, isn't that it? No,
No.
sorry, sir, 23.
Yes, yes.
This will be 2022. SCC is not here. 2022 6 SCR 382. Everything is dealt. We'll have to, because I think after this judgment, we cannot comment anything beyond. Exactly the dot point that has been raised. I think Mr. Bhattacharya, you are go to it.
Numerous writ petitions were filed by across the country
Huh.
on this.
On this point,
When did you hear this?
এইটো তো ফার্স্ট দিন দিছো মই this is the
okay,
judgment.
comma. When? Not day after tomorrow. Let us take it up on next Tuesday,
My lord.
18th. Okay. Please, this.
First item.
It will come as first attempt. That's why we have kept it in the orders, because I want to finish up the orders matters first, and this important matters it will come at as first matter. 19th.
If this is for further hearing, my lord, this is on my part. No, my lord, this is a different footing, my lord. A technical ground for my department. Otherwise, my lord, if it is adjourned, my lord, I have some difficulty, my lord. Means it's simple. For further hearing, my lord will keep.
That it is already part heard.
My lord. My lord, if it is adjourned, I cannot even bill. And then
His in,
This would part which certain amount.
yes.
And I have accommodated.
my practical difficulty.
नाम तो लिख ही दूँ हाँ also present hard at some length for further hearing on such and such.
My lord, my lord.
Yes, why this matter is listed? What about?
About this appeal against equitable manner, state has filed this appeal manner.
State preferred appeal. Take, how will you are for?
My senior's name is there, my lord. I don't know. Can it be taken after some time?
No, that will take up. This matter is listed in the orders.
Yes,
We do
yes.
not want any senior to be here for that. Why this matter is listed for orders? Office note 19.9 says no service report nor ID card in respect of respondent number 2, 3 and 4. This is appeal by state.
State manner, otherwise one appellant expired manner, appellant Sadananda Hazarika. Manner.
No, what about other 2, 3, 4? Appeal number 2, 3, 4.
The respondent is shown in the cause list manner, respondent number on behalf of respondent 2 appeared.
Uh,
SC
you are appearing for whom?
Yeah.
No, which respondent?
I don't have file, my lord.
Please don't come. Please don't come to say that I want adjournment in the orders column because I know nothing. Please don't stand. We'll help ourselves.
Otherwise, manner respondent numbers 2's name shown in the cause list.
Uh,
And many other advocates' name is also there, manner.
Mr. Botchakar, verify it.
Yes.
Ask or any colleague is there. Who appeared for whom any name is shown, whether actually service is complete.
Yes.
If not, then we'll ask for a fresh test. Yes, next case. Yes. Huh?
No, sir.
Yes. If you are standing there, you are for appeal, and yes, tell us.
LCR is received.
Huh?
LCR is received.
LCR is received, that we know. What is to be done here?
6 for hearing.
This is a 2014. Who is respondent number 2? You don't have, people don't have time to see the office note also, na? What is the punish offense, Mr. Botchakar? This is
304 for
3 years,
three.
isn't it?
Yes, 3 years,
So, informant is not necessary.
not necessary.
Office note dated 29th and 2024 reflects that no ID card nor unserved notice in respect of the respondent has been received. Full stop. The present appeal is against an judgment and conviction. An order of judgment and sentence dated 10/4/2004, whereby the petitioner was convicted under section 304 part 2 IPC and was sentenced him to suffer RI for 3 years. Full stop. In view of the extent norm, the respondent informant is not a necessary party. However, said respondent slash informant slash victim shall be at liberty to participate in the proceeding if so desires. In view of the aforesaid, the service is complete. LCR has been received. List this matter for hearing on a date to be fixed by registry. Yes, Mr. Chaudhary.
Last,
Lordship, kindly peruse the last order, my lord.
What is the last order?
Mr. H.R. Sodri appearing in this case, my lord.
Uh,
LCR call for my lord.
uh.
Actually, my lord, I write down this petition. He is engaging earlier my senior, my lord. Subsequently, he has engaged H.R. Sodri. Anyway, my lord, LCR has been called for last order, my lord. Received, no? So your lordship may fix for admission, my lord. Yes, I have is the-
There was an application for listing this petition.
Maybe, my lord, because I am not there, because after my death of senior,
So here we'll take up this matter today.
because HRA Sodri name is not shown.
So you are not in the case.
I don't know, my lord, at the.
What you don't know? We cannot make an inquiry that whether Mr. Sodhuri is
Subsequently, HRA
still
Sodri-
being engaged or not.
H-
HRS Chaudhuri is a senior advocate.
Yes, my lord.
Whether you are assisting Mr.
Sure.
Chaudhuri, whether you are assisting Mr. HRS Chaudhuri,
Yes, yes.
are you assisting?
Yes, my lord.
Yes, Mr. NNB Chaudhuri submits that this matter was supposed to be argued by Mr. HRS Chaudhuri, learned senior counsel, whose name is not reflected in this matter. Senior's name is not required. You'll have to go. You'll have to go and brief him. Anyway,
I got this.
in view of the above, full stop, the matter is ready for hearing. Okay, accordingly, list this matter for hearing on a date
Short date, my
to
lord.
be fixed by registry. No short date, it will come immediately. It's
Yes.
2014.
Yes, my lord.
We have,
2008 incident,
huh?
2008 incident.
Whatsoever, this is not the only case.
Instruction, my lord, I can argue right now, my lord. This case, morning I got the file.
Yes. So, but you are
He
assisting.
said, I'm skipping over the file.
No,
never
he
said
is
it.
not saying that.
Yes,
He
sir.
said that given early date.
I
That's all.
told him whether client want to argue me or.
Yes, then on a date to be fixed by registry. See, we are streamlining the things. We have started from 2011.
Yeah.
2005 matters were pending. We have finished it up. We have come at least to 2011. So hopefully by end of this year, we'll be able to come to around 2015, trying it.
The HRA Sodri name maybe.
Okay, registry to review.
Upon Apollo case.
Yes,
Lordship, I have sought instruction. Actually, the petitioner has died.
Hmm.
Now there, I'll file appropriate application today, Lordship.
okay. The learned counsel for the petitioner submits that the petitioner had in the meantime expired and he has already filed an application for substitution is being filed during the course of the day. Full stop. In view of that, matter stands adjourned and be listed. Listed. Huh? After 4 o'clock.
There's a office note of dated 26/9/2024.
Hmm.
The etiquettes are received back by the concerned section.
This matter is ready as regards service, is not it?
6/9/2024.
In terms of office note dated 26/9/2024, this matter is ready as regards service. Full stop. That LCR is here.
Received.
LCR has already been received.
T24, T26, 1 year and 3 years.
Accordingly, list this matter. List this matter for hearing on a date to be fixed by registry.
My lord, we had filed an affidavit, which was not on record.
That we have called it.
Yes.
It is there.
My lord.
Now, Mr. The Gogoi, let us understand. See, otherwise, I have gone through everything, your
Yes.
argument. I have noted it down. I am ready to proceed for a
Order.
judgment.
Yes.
Okay, now you have filed an affidavit at this stage. I think,
No, it was filed.
no, not at this stage.
Pursuant to your lordship
Percent-
direction.
Yes, yes, that is fine. Now, I want to know them, anything you want to add or will adjourn it or,
Reply to that, man, please.
okay, fine.
From our side.
Since he has filed, we will reply to that. That's all. Then
But
we'll, then if you want some notes and all, written note of argument and anything, you add that. And if you want, if you want to orally argue, because your facts are already in the affidavit.
My lord,
Mm.
will supplement by written argument.
That is what I am saying. Because till now, whatever you have argued, I have already dictated, noted it down. Now what I need to, I'll just little go through the,
If your lordship kindly permits,
Mm.
I'd just like to read 3 paragraphs from this affidavit.
not today,
Okay, okay.
not today, since
Okay.
they are
Okay.
not there.
Give a reply, Manoj, and also Manoj, we make some just oral statement on this particular argument.
That's all. So
Only on
therefore,
this
give us a
affidavit.
date. Give us a date. On that day, we make it CAV.
Yes.
Because though I have completed almost your arguments, my application of mine will need some time.
It will go through.
So, 20 तारीख को पैसा देने का हो गया।
26 of Bishop.
हाँ, हाँ,
27, 28 of Thursday.
हो गया।
28 man.
28,
This
okay.
month. only.
An affidavit, additional affidavit has been filed. But what is this called? What is your additional affidavit?
Additional affidavit.
Additional affidavit has been filed by the petitioner. In view, bringing some new materials.
Not new
No,
meeting,
okay,
my lord.
okay.
All the lordship wanted
Okay.
that he was the chairman of
Okay,
the
okay,
GMD then.
okay.
That-
Okay, accordingly, let the matter be listed on
28/11.
28/11/2024 to so that the respondent may respond to such additional affidavit and file their response if so advised. If okay,
If-
and then if you give some notes and all on that day,
That they will.
other parts it is over almost.
Yes, man.
I
Other
have
parts we have
already
only
we
on
have-
this point we will clarify, but
Okay.
otherwise.
Already everything I have in fact dictated all your arguments.
If we give our bullet points, that will do, or lordship wants a detailed thing.
No, not details, just your short, what synopsis and what your basic fundamental 2 lines, 1 point. This is my argument. This is not as a lengthy
No, no,
argument. Because I have already
Second
dictated.
one,
I have dictated, but I'll just see if you have added anything more so that I can incorporate in my judgment.
yes.
That's all.
Yes.
And facts you can, as per your, that you can give how the things develop.
How
I have
develop.
already dictated, but
Yes.
still I want a clarification. See, the facts I have dictated, your arguments already I have dictated, but I want to have a tally that whether I have committed some mistake here and there in
Actually,
recording the facts. Or anything is to be added. I might have missed some arguments, so that I will add if additional things are there.
May I please, your lordship? Lordship, here, I have
Ah.
received some instruction, lordship. This accused lordship, petitioner, he came through an advocate, lordship. He was an old person, lordship.
Hmm.
And I have received instruction that he has expired. But I could not collect the death certificate because the family members, they are not cooperating. lordship.
Okay, a learned counsel for the petitioner submits that the petitioner has in the meantime expired, full stop, and that he has not been able to contact with the legal years, full stop. Be that as it may, as the petitioner has already expired, this matter stands closed. Matter stands closed. Interim order, if any, stands vacated. Full stop. However, it is if the legal years, if desires, they may file appropriate application. Full stop. Huh? In view of the order passed in so and so, so and so. It stands closed. Item number.
As per last order, my lord, service complete, my lord.
Are you having a brief? Any record with you?
No, my lord, I have gone through the
No, first which one was the first FIR? She's just take down 23 07 2013. Twenty-four 07 2013. CR MCR. Can you have the status of this case, GR case, or police station to search it?
from
First-
police station we can take, but
But-
if ZR it will through registry it will come.
Uh, any LCR is any record is there? No.
CD part is there, LCR, CD part only is here.
Court part is not there. Why record has come? No record was called for. None appears. for the petitioner on call. The present application is filed under section 482 CRPC. Seeking quashment of GR case number 986/2013 arising out of Morigaon Police Station case number 251/2013 under section 383 theft and 411 under section 380/411 of the Indian Penal Code. Full stop.
Honestly receiving stolen property.
Anyway. Okay. The brief fact leading to the present case as projected by the petitioner and available petitioner as pleaded and projected by the petitioner in her petition as well as from LCR. It is seen that the petitioner is an advocate practicing at Morigaon Court. Morigaon Court. Full stop. On 23/7/2013, the FIR in question was lodged by one Bogaram Deka, who was the bench assistant of the Sub-Divisional Judicial Magistrate, the Court of the Sub-Divisional Judicial Magistrate, Morigaon. FIR was lost by full stop. As per the informant, on 23/7/13, the petitioner accused wanted to go through the record of GR 2027/2010 and such record was allowed to be inspected by one police constable Muhammad Montuz Ali. According to the informant, the said advocate offered money to said constable and wanted to take back the original land revenue receipts deposited in connection with bail. Land received deposit in the name of one Mongol Singh Bordoloi, another accused Mongol Singh Bordoloi, which was deposited in connection with a bail application. According to the informant, when they refused to part with the record, the accused forcefully taken away the original land receipt and in the process of one part of the receipt was torn. Full stop. Accordingly, Morigaon PS case number 251 Swensu under Swensu was registered. Subsequently, after completion of the investigation, charge sheet was filed before the court and same is pending trial before the learned Chief Judicial Magistrate, Morigaon. Full stop. It is the case of the petitioner that such FIR was lodged to protect the informant from their misdeed, inasmuch as it is her case that the petitioner wanted the original land revenue receipt of the bailer who deposited it in connection with a bail application. And in this regard, she had also filed an application before the learned subdivisional judicial magistrate, pleading that 23-4, huh? 23-4. Bottom to 23-4. FRS 23-4 question, huh? 23-4. And lodged on 23-4-2027. With a prayer date. To allow the take land revenue paid receipt from the record. Such application was put up on 30-4-2013. (23-7) আগৰ কেইটা 23-7 2013.
My statement of the other witnesses are also.
Dear,
my lord.
this application
My lord,
not
perhaps
no.
after file after that incident, my lord, perhaps. Well, initially what happened, my lord, when taken away, some of the witness, my lord, Kamal Kolita, he showed that it was handed over to the Mongol Singh, Bordole.
Yes,
Thereafter, she returned back
Yeah.
and said that I will return the original receipt. Then refused. Court not
That-
assistant. Refused and said that you will send it or through an application. Perhaps that application is given later on, as per the statement of the my lord, witnesses.
I will give we're spending time, na?
My lord.
The lawyer will be imposed with a cost of 10,000. As simple as that, and to be deposited before bar council. However, no order was passed in the aforesaid application. Let's see. Any order on this petition, please look into the courts. She made a statement that this is the statement. When the informant, despite repeated requests made to him, did not return by his limit, but he was then only petitioner being engaged counsel went to the court and asked for the same as per the order given by the learned judicial magistrate first class. Where is that order? There is no order. Please look into. কি করলো last ওখানে? No order was no order is available on the record. No order was passed in available on record as is discernible from the LCR. Be that as it may, after filing of the FIR by the bench assistant, the petitioner filed a CR complaint case on 24/7/2013 before the learned Chief Judicial Magistrate Morigaon, which was registered as CR case number 1332/2013. First up, as per the aforesaid application, CR case, the accused bench assistant and the constable demanded bribe from the petitioner. The constable and one peon of the court of the Judicial Magistrate First Class Morigaon to allow her to look into the record. And thereafter, they falsely lodged the allegation that the petitioner has stolen the land revenue paid received. First up, in the aforesaid backdrop, however, there is no order in this record to it. That line will go later on when I will find dictate my part. Full stop. The fundamental challenge in this case is that the the FIR has been lodged by the bench assistant with malafide intention and to cover up their misdeed of demanding bribe to allow the petitioner advocate to go through the record. Demanded bribe to allow her to take the relevant land revenue received. According to the petitioner has been robbed in the case on the collective mischief of the informant and other vested interested persons who are making all possible effort for last few months to tarnish the professional career of the petitioner as an advocate in the esteem of the public. According to her, the allegations are false and self-manufactured, which evident from the fact that the documents which alleged to have been stolen by the petitioner are still available in case record of CR case number 2027/2010. And in this regard, the petitioner has relied upon a certified copy of the aforesaid document. Next. Full stop. As recorded herein above, none appeared for the petitioner to none appears for the petitioner to address this court. Address this court. Therefore, this court has gone into the pleadings and statements made in the petition, comma, in the FIR lodged by the respondent / bench assistant of the court in question, comma, the complaint petition filed by the petitioner as well as the LCR and case diary of Morigaon PS case number so and so, including the statement of the statement recorded by the investigating authority under section 161 CRPC. First, in so versus so, the Honorable Apex Court has observed that when there is an allegation of malafide in lodging an FIR, the court, while exercising power under section 482, may also look into the materials available on record to ascertain can also look into and rely on the materials available on record so as to ascertain whether the case is filed malafide and oblique or it is an abuse of the process of court or it is abuse of the process of court. Full stop. In view of the settled proposition, this court has also gone through the materials available on record, though it is a petition under section 482 of quashment of the FIR. From the material available on record, it is seen that actually incident happened in the it's the materials available on record. The aforesaid material suggests that there was an incident in the court of the subdivisional judicial magistrate as regards taking back the land revenue received, which was deposited in connection with which was deposited by a bailior for release of an accused in the said case. Full stop. It is also seen that subsequently said document was seized from the possession of the co-accused, with who was the co-accused, that is the bailior, in whose name such certificate was issued. The other statement made also supported the projections made by the prosecution. In the aforesaid backdrop, the charge sheet was filed. Full stop. Therefore, charge sheet was filed, and fact also remains that the FIR was lodged on 23/7/2013, and the complaint was filed by the present petitioner on 24/7/2013. Full stop. Though a statement is made in the application that the subdivisional magistrate allowed to take back the record, however, except filing and petition on 23 on some 4 question application on 34/2024, nothing is on record reflecting any order that has been passed in the aforesaid application. Full stop. Therefore, it cannot be said that the allegation on the basis of aforesaid material, it cannot be said that the FIR was lodged with a mala fide intention and to harass the petitioner advocate, nor it can be cannot be said as so and so. Full stop. Even otherwise, if this court takes the FIR on its face value and accepts the same to be correct, in the considered opinion, the same discloses the offenses as alleged. Full stop. That being the position, in the totality of the matter, this court would not like to exercise power under section 482 to quash the FIR as well as charge sheet and the GR proceeding itself for want of the materials required to exercise such a power, and as discussed here in above. Accordingly, the criminal petition stands dismissed. While parting with this court would like to put on record that this matter is pending since the year 2014. And though the petitioner is being duly represented by the councils, namely Nambilak Solterio, so and so. However, none appears for the petitioners to present their case. there is nothing on record even to suggest that the learned counsel has withdrawn from the brief. That being the position, this court is a prima facie view that such conduct on the part of the such conduct on the part of the counsel representing a petitioner may amount to misconduct. However, however, this court will not proceed further in this regard, but at the same time would like to impose a cost of rupees 5,000 upon the counsel who are engaged in this court. Full stop. Accordingly, registry should bring on notice of the fact of passing this order and imposition of cost to the learned counsel, and the learned counsel shall deposit the aforesaid amount in the accounts of Guwahati High Court Bar Association, what is called total likhebo, within a period of 15 days from the date of receipt of an order to be furnished by registry upon them. Dispose them.
Yeah, please, Your Lordship.
Yes.
In this matter, we have newly engaged counsel, my lord. As what will appeal in this matter, we will list next Tuesday, my lord. Both the matter.
Next Tuesday, not Tuesday. When? Will this matter fix in the admission? No problem. That's a hearing matter, not a hearing matter. So give a date. 19th. Yes.
19th.
So I am for the earlier council. We are not our council. Our names are reflected in the cause list.
It is submitted that you are Mr.
H. Agarwal.
A.
H. Agarwal.
H.
Appearing on behalf of-
H. Agarwal appearing on behalf of, we cannot say BDK is disengaged. Seniors are not engaged. Seniors are assisted by their juniors. Client do not engage senior. Don't demean the position of the senior advocates.
So the other councils are also mentioned.
Who are under counsel?
R. Kolita.
Where is R. Kolita is available? In High Court. Is he available?
I will look for.
It is submitted by the learned counsel from the chamber of BD Core, learned senior counsel. If you want to demean, we'll demean him. That they have been disengaged in this case. Disengaged in this case. At the same time, MS P.
Bora.
P. Bora, learned counsel submits that they have been recently engaged in this case. Accordingly, she seeks for an adjournment. In view of the aforesaid, registry to list this matter on 19th of December 2024, reflecting names of Mr. S. Bhattakur and MSP Bora, learned counsel, and delete the name of Mr. B.D. Kaur, R. Kolita, P. Bora, S. Saloy, S. Burwan, MS J.
P. Bora, I am there.
Okay, P. Bora is there. Okay. Delete the name of JM S. Borua and JM Kaur. MSP Bora to naam to nahi diba, baki khin thakin.
Lordship,
Please.
19 of this month, my lord.
Yes.
But-
No.
No. I'm praying for 19 of this month, but
No, it's the 19th of this month. Yes, this month.
oblate.
Why time being? Okay. Okay, office note dated 31 8/2020 reflects that that the registry has received service report from the SP Bongaigaon which suggests that the notices has been served upon the accused respondent number 1 to 4. Only 4 respondents are there? Huh? Only 1 to 4 or any other?
Already notice deemed to be served, one order. is
Okay,
also
okay.
there.
Why this order is here? Aritu? Leave is granted or not? It is disposed of Hussein Hawani. Huh? Leave is also pending. Yes, yes. Criminal Appeal 209. There is also a leave application. Leave is not disposed of. IA लिखेगा. Huh? IA number? IA number 19 of 12. None appears for the petitioner on call. The present application, this matter is ready as regards service. The yes, yeah.
Two, my lord. Senior counsel,
Okay, Mr.
Yeah.
Huh?
Yeah, mate.
A. Ahmed is present for respondent number 2 and Mr. Borthakur for the respondent
State-
number 1. None
No.
appears. Huh?
I am for the state of Assam. my-
State of Assam.
State of-
State of Assam.
Agree.
Other respondents are not being represented, though notices are duly served. The
No,
present,
I am the state is the appellant, my lord. State has filed this for.
okay,
appeal
this is state is appellant.
Yes, my lord.
Now, what is to be granted? What is to be done?
The service completed. They have.
Service completed, full stop. Is an application under Swencho. This is an application under, why leave is required for to prefer appeal against acquittal?
Yes.
Against acquittal.
Acquittal, my lord.
Okay. The present petition under section 378 within bracket 3 of the Code of Criminal Procedure 1973, praying for leave to appeal against acquittal is filed by the state. State to Julie Nukuma heard Mr. Borthakur run counsel for the applicant state. Okay. He is not a respondent. He is an applicant. The present application petition is filed Swencho. Appeal against the judgment and order dated 29/5/2012 passed by the learned additional session judge within bracket FTC, Bongaigaon in session case number 25 within bracket J/2000, whereby the respondents were acquitted under section 304/149 IPC, were acquitted from the charges of commission of offense
Yes.
under section 304/149 IPC. Full stop. Peruse the ground of preferring appeal against acquittal. Full stop. The respondent has not filed any objection opposing such grant of leave. Full stop. Perusal of the ground discloses that the state has made out a case for grant of leave. Full stop. Accordingly, leave to prefer appeal
Yes.
is granted. IA stands dismissed. IA stands allowed. IA stands allowed. Okay. In view of The order passed in IS so. Let the registry list this is in criminal appeal, huh? List this appeal for admission next week.
Yes.
That's all.
May I please your lordship, the matter may be passable for time being.
You are for?
Respondent, BK Sen.
Huh?
On behalf, I'm appearing on behalf of BK Sen, respondent.
Vacation respondent. Petitioner is not here. We'll see. Yes, for the time being. For the time being, yes.
Kindly pass over the matter for time being, madam. Mr. Azad Ahmed will appear in this matter.
Hmm?
Azad Ahmed will appear in this matter, madam.
Oh, please, Your Lordship, during the pendency of this petition, petitioner is expired, my lordship.
You don't want to propose. It is submitted by the learned counsel for the petitioner that during the pendency of this appeal, the petitioner has in the meantime expired. And she has instruction from her client. She has and the legaliers are not interested in pursuing this matter further. In view of the aforesaid, the present revision petition stands dismissed. Interim order, if any, stands vacated.
Your Lordship, you may pass over the time being.
Because petitioner is expired.
Hmm.
Yesterday I got the information. So they can be taken after 4 weeks. In the meantime, whether they are intending to pursue this matter.
Mr. S.P. Chaudhuri, learned counsel for the petitioner, submits that the petitioner has in the meantime expired and he is awaiting instruction from his legaliers in this regard. Accordingly, he prays for an adjournment. Prayer stands allowed. Please this matter after 4 weeks in the order column. In the order column. Yes, Mr. Dasgupta.
My pleasure, Lordship.
Hmm.
There's a long pending case.
Hmm.
Still is a case of demand for dowry.
Hmm.
The occurrence took place in the year 2007.
Hmm.
Thereafter, the victim got married.
Hmm.
He is now staying with somebody else.
Hmm.
We prepared an appeal. The appellate court also affirmed the judgment of the learned judicial magistrate. And now we have filed this application under 482. The one thing that I would like to place before your lordship, that the prosecution has not examined investigation officer, IO. IO has not examined that. That is one of the irregularity that I found. And as a result, the statement which was made before under section 161 and the prosecution before the prosecutor in the court, that could not be contradicted.
Did you contradict those statements with the person who made statements under 161? Then it will be vital, otherwise not. Did you confronted those statements with those?
PW1 and PW2.
Okay, and what are the other grounds?
That is the main ground that I found. And this is the main ground that what happened.
But what the law says in this connection, whether in exercise of under section 482 CRPC, we can interfere. How this court dealt with, was it an argument before the appellate court?
Yes, that was.
How it was dealt with by the appellate court? How the trial court dealt with non-examination of the IU? That is first vital point. Then whether you raised that issue before the appellate court, that is the another issue. Depending upon, suppose it was properly taken, then it will be, we'll go, because we'll not go to the factual assertions. It is a 482 application. Now, how you are prejudiced for that, and whether on that ground only can vitiate your prejudice you, and it's a failure of justice. This is the limited argument you can have. Let us proceed on that. Are you ready?
Actually, not fully ready, but
That I
tomorrow
could understand.
can-
Tomorrow.
or day after tomorrow, any day.
Tomorrow.
These are the points
This-
that.
See, we are in a 482. Law is well settled. Yes, we are not powerless in a revisional process. We can go into. Even we can reappreciate evidence when you can show that there is a perversity. Without perversity, we will not go this concurrent findings effect. So other issue is that it has committed, trial court has absolutely ignored a settled legal proposition, resulted in your prejudice. That can be one of your ground, which you say that IU was not examined, because we could not contradict them. That is a very vital point. But whether that contradictions were brought to the person who made this statement,
Yes.
and whether it was under in terms of 145 of the Evidence Act. 145? Evidence Act. This to that extent we can go, but we cannot reappreciate. And other issue is that how fatal it would be if an IU is not examined, and if otherwise the evidence of the prosecution witness are firm and has not been shaken by cross-examination. What will be the legal implications of only can a person be acquitted only on the basis of non-examination of the IU? This is the third issue. You'll have to answer this. Legal questions.
All right.
Day after
Yeah.
tomorrow.
Yeah.
On the prayer of Mr. Das Gupta, matter stands adjourned and be listed day after tomorrow.
Please, Your Lordship, I appear in item number 19, Lordship. Item number 19 and 22. There's some personal difficulty on behalf of Mr. A.M. Bora, Lordship. Kindly let the matter come up after a week, Lordship.
What is the
There is a series of matter, Lordship, but on the last occasion also in item number 18, as per the order, none had appeared. I appear in item number 19 and 22. The other councils are not.
Oh, forget about others. We'll appoint amicus. But it cannot go for a week. Difficult.
Because the other councils are also not here.
Forget about them. Forget it will be difficult. We'll start what is. But see, this is the end of this list. At 12, a judge will sit idle. It is not permitted. It is criminal wastage of time. Let us see what is what. Yes. Let us understand. Yes, what is the case? Here?
Lordship, unfortunately, the brief is also not available.
Okay. Be without brief. Let the CBI be briefless. No problem on that. Okay, give the file. Record. I'll share.
After Parade Lordship 2021, this matter has not been listed.
Mr. Haloy, don't say that. At least say that at least it has been listed. So let us not again adjourn it. Better say positive things, not negative. Evidence of file to you. Out of the same judgment,
Arising out of the same.
same evidence. How many witnesses?
30, just I have seen the record 35, I think.
535.
Mm.
Verify that.
LCR also it says 15 files.
Huh?
Total 15 files LCR. So I believe all the LCRs are not here. Maybe. What a file there.
Call them. Files it difficult then. লিখিবাচোন। Deposition of PWs 71 to 155 and deposition of DWs 156 to 159. 313 statement 160 to 361. Then এটা হেৰি কৰাচোন। These are most of them are exhibits files. এইটো তুমি হেৰি বুলি লিখি থব প্ৰথম কাৰ্ড মাৰি exhibits বুলি। So these are the exhibits. Okay. Is 71. What is the genesis of the case? Yes. Case কেটা নালাগে এইবিলাক দৰকাৰ নাই, এইবিলাক কোনো ৰিলিভেন্স। প্ৰথমতে শুনা মৌচুমী ইয়াতে we'll take it up tomorrow, okay? এই বস্তুখিনি এয়া তাৰমানে 21 ৰ পৰা তাইক যে ক'লো এভিডেন্স
Can it be taken upon 13 Lordship? Tomorrow, one more criminal appeal, voluminous appeal, Lordship, Sahadev Chakma, 8 bound volume, Lordship.
This is 159. This is to this, huh? 159. What was the conviction? That is what you do not know. What, Mr. Chaudhary? Sorry, I never expected it from you. That even if you were not aware what was your conviction for your client, you should not come and make statement that I am representing the accused. Evidence के उल्ले एक में जितनी केस बोल तो मैं हैंडी हो give the list hearing list or our seat that we have prepared. Mujal, that hearing part, how many meters you fixed? Hearing data, sir. Well, 14. Started. On 14th. On 14th. But we will not excuse anything on that. We'll start it. How many volumes? We cannot avoid cases for volumes. We cannot. It may take 5 days, no problem on it. We'll continue. We'll start on Thursday.
Apologies. Highly obliged.
My lord,
Yes.
I'm extremely sorry, my lord. I tendered a qualified apology for item number 20, my lord. Just today morning, yesterday I attended a marriage ceremony of my niece. Today, 10:30, I reached here. After going through the, my lord, cause this, my lord, I requested one of my friend kindly appear before the court. Only said at 2 or that day after tomorrow, my lord. Nobody appeared.
We have
my lord.
dismissed it already. With a cost of 5,000 to be paid by you.
Extremely sorry, my lord. On 10:30 today, I reached at Guwahati.
But see, this is maybe, but it is your responsibility to send. We have not done anything when persons are represented and made requests. This is a 2014 matter. We have adjourned it. It is not an issue, but we have already spent almost 45 minutes in your case.
I requested one of my friend, but nobody.
This is your problem. This is not the court's problem.
appeared.
You could have informed the even PP. They could have said that we have been informed.
20 years.
No, not 20. This is
No,
the
9, sorry, 9, item number 9.
9. That we have already passed judgments. We have spent 15 minutes. We observed and will observe that this non-appearance is a prima facie misconduct. So we have observed it today in your case and stop there. In next case, we'll refer it to the Bar Council. Because we cannot decide, you might have many explanations, the explanation like you have given. Tell it to the Bar Council that see, it was not my fault, it was not intent. This is not our job. But we are really not happy with the bar. It is treating a court more particularly in a criminal matters. At 12, we are finished.
Whatever submit is not, my lord, yesterday after 12:30, I attended my medicine was of my cousin. On 10:30, I reached.
I reached home at 1:30 attending my cousin's marriage.
And I
I'm here at 10:30 doing the cases. So these cannot be the explanations. We have already dismissed it. Now we have recorded our reasons. I cannot say that I will ask somebody to delete it. Not possible. I have already dictated.
Hometown Huzai, my lord, not what.
That is, please don't say all this. No, this list is on list was notified on Friday.
Friday morning.
This is your responsibility. Could have told it is your failure. You deal with this. Your dismissal order is final, but since you have appeared, last part will delete. Pause. We have dismissed it. Yes, how many matters are there? Okay. First minute on here. Yes, Mahajan, what was this?
Prepared, not a compilation. It is all the evidence in one place.
Okay.
Also handed one copy to the learned people.
Just now I have received the copy.
Just what was the conviction? It is a revision, isn't it?
Yes, sir.
Criminal revision. Okay.
376 for 7 years.
370 for 7 years.
7 years. Petitioner is on bail, my lord.
Who is PW1?
PW1 is the aunt, my lord. She is the informant, my lord. So here what has happened?
Just I will mark the who are who, then we will come back to the evidence.
My lord.
PW1 is
Aunt.
informant. And PW4?
2 is the, my lord, victim.
PW2 is victim. Then
PW3 is doctor, my lord. Medical officer.
doctor. PW4 is
This one IO, my lord. He submitted charge sheet, my lord.
IOCS. Then PW5
5 is the IO.
IO. Basically, why it is revision?
My lord, assistant session judge appeal here, my lord.
Okay. Is it an appeal lies to the
No, my lord. Revision will lie to the High Court. my
No,
lord.
no, that is what I'm saying. Offense under section 376 is triable by whom?
Tribal session judge, my lord. It is session judge. my lord.
So if it is session judge, how an appeal was taken to, see, as if a jurisdiction is of a session judge,
Yes.
the jurisdiction may be conferred to an assistant session judge, but he's exercising his power as a session judge. So if he's exercising power as a session judge, can an appeal will lie before the session judge? Delegation of jurisdiction is of a session judge.
Yes.
The CRPC says that this offense is to be tried by a session judge, isn't it? Now, an assistant session judge can also do it, provided he is been conferred. Now, that is to be done, he will exercise the power of session judge. Please correct me.
Yeah,
If
my
that be so, then how an appeal lie to him, to himself,
Yes,
session judge?
exactly.
Well, because 374, my lord.
Please, I have a little confusion. Let
Yes,
me be candid and fair. I have little bit confusion in this regard. Because I earlier dealt with a similar case. There is those issues were there. There is some provision, I think, which permits in some circumstances.
374,
Huh?
374 3, my lord, CRPC.
374(3). Yes, what it says?
Same as otherwise provided in subsection 2, any person
Hmm.
convicted on a trial
Hmm.
held by a metropolitan magistrate or assistant sessions judge or magistrate of the first class or the second class or may appeal to the Court of Sessions. my lord.
No, that's fine. But you plus first tell us how a trial be conducted by a assistant session judge of a offense committed under 376 at that relevant point of time.
At the delivery, it was trialable by a Court of Sessions. my lord. It did not say assistant or
So court of session.
I got the old, that is why. Yes, my lord.
So if it is court of session, am I clear? If it is by court of session, jurisdiction is something that it has been said it is by court of session. Suppose a civil judge senior division, for the purpose of there is some provision in CRBC which says that it can, district judge can, session judge can delegate its thing. So if it is a delegated power, then 376, he is acting as a session judge for the purpose of that trial. Isn't it? Am I
Yes.
clear? I'm not clear, my confusion. So please let us see first under which provision it is a trial is to be conducted by in that relevant point of time. What was the offense punishable when it was committed and who is to try it?
Yes.
Let us see that.
Offense was 2/9/2007, my lord.
2007. What was the relevant provision of 376 at that point of time?
Hmm?
376 that
No,
time, my
it
lord,
didn't-
it was not amended, my lord. It was minimum of 7 years.
So minimum was 7 years. So it is to be tried by,
It is to be trialable by a Court of Session.
so if it is a court of session, now let us see what is the power of the court of session to delegate.
That I don't know.
His session judge may take unto himself and also there is something like that.
Power of court. 29/2007.
So then, if it is a trial by a authority without jurisdiction, matter ends there. Where is the question of appeal?
Section 10, my lord.
Section 10 of,
Yeah.
yes, read it.
Subordination of assistant sessions judge.
Hmm.
All assistant sessions judge shall be subordinate to the sessions judge in whose court
Hmm.
they exercise jurisdiction.
Hmm.
The sessions judge may from time to time make rules consistent with this code as to a distribution of business among assistant sessions judges.
Hmm.
The sessions judge may also make provision for the disposal of any urgent application in the event of his absence
Hmm.
or inability to act by an additional or assistant sessions judge, or if there be no additional or assistant sessions judge by the chief judicial magistrate, for every such judge, a magistrate shall be deemed to have jurisdiction to deal with any such application.
So it's a conferment of jurisdiction. So as if
Session
as
judge confers to the-
consequences jurisdiction, so he gives an assistant judge authority. So for all meaning and purport, will it not mean that it has been passed, judgment is delivered by a court of session?
Yes,
If it is a court of session,
has to be
appeal is to be before High Court.
yes.
Yes, Ahmed.
The Court of Session is specifically defined in 9 and subclause 4 lots.
What is
That,
different?
Session judge and additional session judge are treated to be as.
That we understand. Therefore, I am not saying additional. Two issues here. First thing first, to try it by an assistant session judge, there must be a delegation under section 10. Isn't it? In certain circumstances, let us not go to those circumstances. If it is delegated, he acts as a court of session. I am not saying about the session judge. So if he acts as a court of session, appeal will lie before the session judge.
But,
it is
section
may,
nine-
my lord.
Huh?
But
It is may.
section 9 subclause 4 says that session judge and additional will be the sessions division. So he will not
Understand,
be under the sessions division.
understand. So for there may be two situations. Either the trial itself is without a by a court which is not having the jurisdiction. Either, or if he has duly delegated under section 10, then appeal will lie to High Court.
But, section 374 says that if it is not above 7 years, then it has to be before the sessions.
It is to be sessions goes through, not if the
That-
sentence.
Yes, that specifically it is there.
But see, that we understand. Suppose a session just passes a order be less than 7 years, then
Come to High Court.
to High Court. Why? Because it is passed by a session judge. You want to say when it is, even if it is delegated, and even it is he has acts as a sessions court, then also appeal will lie to a session judge.
74 is specific that from the assistant session judge, it is there.
Three-
374.
374,
374 3, my lord.
374, 3.
74 3A.
374. Okay, let me get it clear here today itself. Because I am having a difficulty here.
74 subclause 3.
Just a minute, 374. Hmm. 374 subclause 3. Okay, let us read appeals from conviction. Any person convicted on trial held by a high court in its original jurisdiction shall to the Supreme Court. One is we have no business. Two is any person convicted on a trial held by a session judge or an additional judge or a trial held by any other court in which sentence of imprisonment for more than 7 years.
We fall in that
Yes,
category of
yes.
any other court.
For 7 years may appeal to High Court, save as otherwise provided under subsection 2. A conviction or trial held by metropolitan magistrate or assistant session judge or magistrate of first class or a second class or a sentence. So you want to A.
That here it is said that trial. It is not said that sessions trial or magistrate trial. That word is not there.
Okay, just for academics. According to you, assistant session judge convicted. So in terms of 374A, may appeal to the session. So when a judgment is passed by an assistant session judge,
Before 10 years, my lord, then High Court.
no, understand, let us, if it is less than 7 or less, up to 7. So up to 7, if sentence is up to 7, it will be to the sessions. Okay. Now, this is one aspect, looking into at one aspect. The other aspect is the assistant session judge is not having any jurisdiction under the code to try offense under section 376.
One view can be.
Huh?
That-
No, this is a fact. This is a proposition of law. 376 cannot be tried by an assistant session judge.
Yes.
He is not having jurisdiction. It will a quorum non judice. Fine. But that is permissible under a provision of the code itself. Because it is exclusively triable by session. Now there is a power of delegation. If that power is delegated, he assumes jurisdiction. He assumes jurisdiction to try an offense which is triable by the session judge. So he is acting not as an assistant session judge. He is exercising his jurisdiction as a session judge. So if it is just 7 years also by a session judge, it will lie to whom?
In High Court.
Then High Court.
That would-
Here it says that here is trial by assistant session judge. But here the trial is not by though it is by assistant session judge, it is jurisdiction, he has exercised jurisdiction as a session judge. Any judgment on this?
One judgment is there passed by Honorable Retired Justice C.R. Sharma sir. That I have to find out.
But how it is explained? See, this I want to create my clear my mind. 3 things are, it is simply you cannot go by this language. Tried by assistant session judge. He is exercising, conducted the trial, not an assistant session judge. Under a delegation of power as session judge. So will that come under C 376(3)?
Probably that aspect is not there in the judgment which I have.
That
Only
aspect is not
it is
there
only
in
said
the-
that 374 says that assistant session judge appeal will have.
So see, I think this is an important question.
Yes, sir.
This is not, this is new, my lord.
Otherwise, my lord, power of all courts is specifically defined under.
Basically, it's defined. So in this section 3, it has presumed. See, there are 3 things. Say, suppose this conviction is above this, whichever does course, it will come to High Court.
Yes.
Well, this is one way into looking it. Other thing is that if it is session, it will be to the High Court. If it is High Court, it will go to the Supreme Court. This is a hierarchy. Then next is a jurisdiction. Trial jurisdiction. Some offenses are to be tried by magistrate. Some offenses are tried to be sessions. Here is a case which can only be tried by a sessions, not by a magistrate. Yes, a magistrate can also try a 376, provided it is delegation is given. So will you mean that this is a trial by magistrate?
Because of this reasons in New Act Lordship that assistant session judge post is not there.
Yes, my lord.
That
We
is
remove-
now.
That is why. So this is how will you, so suppose if either way, if delegation is there, it was rightly exercised. So therefore, then appeal is without jurisdiction. Then we may convert it to an appeal, giving a detailed judgment, and then he is in an advantageous position to we can deal with each and every evidence.
Yes, my lord.
This is one way. Other way is that suppose in record we'll have to see there is no delegation to the assistant judge, session judge. Then whole and trial VCH gets VCH because it is quorum non judice.
There will be one order that transfer this case.
Transfer.
That order will be.
But there are other issues. That transfer also cannot be a regular matter. There are certain conditions when it can. Anyway, we are not going to all this. If there is a delegation, definitely there will be a delegation. Otherwise, assistant session judge will not take. So how you address this? Some judgments on this point? Some research, Mr. Mahajan?
I'll do, my lord. This is
Otherwise, my lord, in this case, in this type of many cases are, my lord.
That's why
pending.
I have seen it.
It's also similar. So that
Huh?
is convicted by assistant session judge, appeal file before session judge. Now I am before.
Which one is yours?
Item 13.
We are taking this matter when? How many time? How much time you require?
Wednesday, my lord.
Parameters will be different. Suppose you say that yes, revision will lie. then revisions parameter after two courts findings of facts is totally different. Totally, we will not reappreciate the evidence until and unless prima facie you can show that these are the perversity. Then we'll go, of course. But otherwise, things are limited. In a first appeal, we'll have to go details to the evidence. This is the last court of facts and law. Let us get it cleared by two young lawyers, Mr. Bhattacharya, you also. Have a discussion. Or at the end of the day, it may be things that, yeah, this is a clear judgment why these judges put these questions once again.
Idea also, I have seen this topic and some research I have done earlier. But regarding this aspect, probably no clear-cut judgment I have found. But still, I will try, Lordship.
You try, and you also try some judgments which says what is a jurisdiction to the subject matter. And what is the effect of a coram non judice? That is very important.
In one case, Mallar, we had filed an appeal, man.
Hmm.
I did not see assistant session judge in the judgment.
Hmm.
I filed the High Court, Mallar. It was sent back to the session judgment.
But there must be, see, that is fine.
One line-
But there must be a reason why. If I do not put this question, I'll straight away go under sufficiency. Where nobody has, you have also not argued, they have also not raised, or they have also not argued. But this has come to my mind since long. I'm getting this answer. So there may be settled proposition of law which I am not aware. I want your assistance. I may not be aware. Because until and unless you know something which is already settled, this question has come into my mind, and it's not possible to know all each and every law.
Yes.
And that judgment will come in a way, Lordship, that passed by Honorable Justice C.R. Sharma, sir.
What, let it, I may accept that this is the proposition of law.
I will place all the.
If I differ, then I may say, this is not a proper way.
I will place.
Deciding your matter on the basis of that, I may refer that this is my view. So let this legal issue be settled.
Yes.
We do not know. We do not know. These matters may be pending matters, may we decide on that. What is the judgment tell us? Are you having?
Judgment by name, I will search.
You search it and give it. Yes, Muslim when? Of November.
That's fine.
Hard at some length. Both cases, huh? Hard at some length. List this separate order. List this matter for further hearing on 26th. Or if you get before that, just give me the judgment. That's this concept is that my thought process is already settled. This is wrong. So we'll proceed that.
Well, kindly fix it on 28th of November. Well, 26 probably I may not be available. On
Okay, 28.
28.
Registry to reflect name of Mr. Bhattacharya in the cause list. Both. Let us.
Quorum non judice that without a jurisdiction, Mallar, and the other one was, Mallar.
One is quorum non judice and other is basically how jurisdiction is conferred. And these issues, see, three aspects of this matter. One is the code confers jurisdiction to certain cases by certain courts, depending upon the period of sentence. Is not it? Basically, fundamentally, this up to 7, this up to 10, above 7, this. So, by virtue of that provision, to try an offense under section 376 is conferred upon a court of session. Okay? So, only a court of session can try this offense.
If there's a judgment that says session judge, assistant session judge.
No, come to that.
Of...
No, come to that. Now, that power of session, don't go by the judge. This is a sessions division. Sessions division is headed by a session judge. So therefore, that session judge is conferred with trying certain offenses, which are conviction is beyond that. And that judge is conferred or is having an appellate jurisdiction. Don't go by judge. Jurisdiction is one jurisdiction is an original jurisdiction to try. Other jurisdiction is appellate jurisdiction. Fine. Now, at the same time, in certain circumstances, the legislature in its wisdom thought that this power of session judge should be delegated to the other authorities which are not at par with which is not having a sessions jurisdiction. That one of them is assistant sessions judge, even a magistrate. Even a magistrate can try a 302. No problem on that. An assistant judge can try a 302, provided the procedure, as per the procedure under section 10, it is delegated. So, in my view, this is my question. When a power is delegated by virtue of a statute, he is exercising a jurisdiction of a session judge, not exercising jurisdiction of an assistant session judge. If that be so, his judgment and conviction, which he is otherwise not entitled to pass, is of a sessions judge. If that be so, whether that subsection 3, which says any sentence less than or equal less than 7 years, appeal can be related in this case. Because it is not a question of sentence, it's a question of jurisdiction. That was here vital issue is the jurisdiction. And if the Supreme Court or any coordinate benches clarified that no, even if it is jurisdiction is there by virtue of 3, the same session judge will take an appeal which he has delegated to exercise his power. And therefore, there are some judgments. So in other matters, what should be the power of a delegate? The authority to delegate and the power of delegate. I have authority to delegate that my judgments can be written by so and so. Now, accordingly, I delegated. Now, that has been done. So, whether he assumes the power of or authority who delegates, or he remains as his own status. If it is own status, then it will come to, by virtue of 3, to the appellate, the higher authority. See, in some judgments, I have passed a judgment in Arunachal Pradesh. Their issue was under Arunachal Pradesh Unauthorized Eviction Premises Act. Their deputy commissioner is the state officer. Okay? And not deputy commissioner, he is the appellate authority. Deputy commissioner is the appellate authority, and his subordinate is the state officer. Here, what deputy commissioner did is, deputy commissioner has made certain observations and decided many things, and he asked the subordinate to proceed with the eviction process. In terms of that, he proceeded with an eviction process. Now, whether this deputy commissioner, being an appellate authority, now can take appeal, because he's already based. This is an individual case. He already has taken. So that is how.
There's some problem sometimes. Here recently I have filed one appeal. In that case, assistant session judge tried the offense under section 376. He convicted me for 7 years. The other person under 376 for 8 years. Now, where my appeal will lie?
That is why, therefore, these issues will arise. Because this is, therefore, he is even having a power to convict a person more than 10 years, which power is conferred upon only upon sessions. So what is his, can he pass a conviction beyond 7 years and assistant session judge?
He can up to 10 years.
Up to 10 years. So can he go beyond 10?
it is tried by him, the accused will be sure that maximum 10 years will be there. But if
No
it is
life.
tried by session judge,
Uh.
it may go to say life.
Yes. But when it is delegated to him, according to me, even he can pass any sentence which can be passed by the sessions. Isn't it? Otherwise, the 376 meaning will go. Suppose I'll assuming for a moment, it's a life is given 302. So by virtue of that provision, if 376 can be tried by assistant session judge, 302 can also be tried. Suppose 302 cleansing evidence. Cannot he pass a conviction of life?
Order of conviction, but for sentence, he has to send it to session judge for passing the appropriate.
So meaning thereby what?
Does not have jurisdiction to pass that sentence.
So he can try. So if he can try, he can pass sentence, appeal. Let us see. You take this provision, important provision, so that for above that, he needs to have an approval for the session. Therefore, there can be an argument that since it is 7 years, less than 7 years, and since there is no confirmation is required, sessions can be appellate authority. That can be another point of view.
Suppose, my
Okay.
lord, by way of delegation or otherwise, my
Mm.
lord, assistant session judge has conducted the trial.
Mm.
As a session judge, because as a session judge, he is under the power of the session judge, he has conducted the trial. Trial concluded. Now, my lord, question is whether the entire trial, because of that, yes, without jurisdiction or entire trial vitiates, or my lord, appellate jurisdiction, because session judge himself has passed the order, and now while sitting as
No, therefore,
judge.
that's why I'm saying, suppose sessions, he has been conferred jurisdiction, he has exercised his jurisdiction. Then definitely trial is not vitiated for that.
Yes.
Appeal will vitiate it. And suppose there is no delegation, that will be definitely there. But another point, what Mr. Ahmed has said, that beyond 10 years, he even cannot pass the sentence. If we bring that analogy to these things, then of course, maybe appeal will lie. That is another aspect. Appeal will lie to the sessions, because in other cases, legislation in its wisdom has not prescribed for affirmation by the session. So since there is no question of affirmation, he can apply his independent mind as appellate authority. Then we'll proceed.
Oblige you.
But in this case, my lord, we are appearing for the respondents.
What is the case?
Case, my lord, it has been filed under section 499, my lord, 500 for defamation.
Hmm.
Now, the fact remains, my lord,
Defamation against?
against, my lord, the petitioner here in this.
You have
revision
filed a defamation. Your clients filed a defamation.
My lord, it is alleged. It is alleged that we have, my lord, we are publisher, my lord, as well as, my lord, editor of Samoyik Prasongo, my lord. There is a newspaper published in the Barakville area, my lord. And daffodil agency, my lord, they are certain, my lord.
So they want to get so their complaint was dismissed.
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 For non-prosecution, my lord, or on few consecutive dates, my lord, they failed, they did not appear. They also filed title suit, my lord, again for damage and all, for defamation.
What happened to that?
That is also dismissed for this, my lord, non-prosecution. Therefore, my lord, they are no longer interested to pursue the, my lord, this proceeding, what I think.
None appears for the petitioner on call. Though Mr. Swencho Sen, PK Sen, Learned Counsel, is present representing the respondents. The present application under section 397/401 of the Code of Criminal Procedure 1973, read with section 482. Agora digo 482, under of so and so, is filed assailing a judgment and order dated 16/6/2011, passed by the learned Subdivisional Judicial Magistrate number 1, Kamrup, Guwahati, in CR case number 3156/2009. By dismissing the complaint case and acquitting the accused, that is the respondents hearing. Accused, that is the editor, Doinik Samoik Prasanga, a daily newspaper published from the district of Silchar, Kachar. Impugn order, where is that impugn order, Mr. Sen?
Order will be there.
Uh, the impugn order reflects that that the complaint was fixed on 28/12/2010 for adducing evidence by the complainant. However, on that date, none represented the complainant nor the complainant was present in the court. Accordingly, matter was fixed on 4/2/2011. On that date, the complainant was absent with step, and on that date, the complainant was asked to take steps to bring its witnesses. However, none did represent on, no witness was brought on that day. Accordingly, matter was again fixed on 17/3/2011 for evidence of the complainants. And on that day also, the complainant was absent without steps. Matter was adjourned and one fixed on 29/4/2011. And on that day, it was submitted by the learned counsel for the complainant. The complainant was sick. On the date, that is on 29/4/2011, the learned magistrate again directed the complainant to take steps to bring its witnesses. Accordingly, it was directed directed that the complainant shall remain present on the next date fixed, that is on 16/6/2011. However, Where is order dated 29/4? কি করলো লাস্ট লাইন তো on 29/4/2011, the learned magistrate directed the complainant to appear before the court on 16/6/2011. Full stop. He was also asked to take steps to bring the witnesses on the said date. However, on 16/6/2011, though the complainant was present, is not it on that day?
Yeah.
But he has not explained why he was absent. He's absent, I think, on that day.
On that day, he was absent,
on-
my lord, did not bring the witnesses.
Okay, on that day also he was absent and did not bring any witnesses. The learned counsel for the complainant do filed an hazira, however, went away without placing anything for the complainant. In view of the aforesaid conduct on the part of the complainant, the learned magistrate, by the impugn order dated 16/6/2011, declined to adjourn the case further, and the case was dismissed and accused were acquitted. Full stop. The said in the considered opinion of this court, the aforesaid facts which are on record in the considered opinion of this court do not disclose any matter, do not disclose commission of any jurisdiction error by the learned magistrate or any action on his part on the part of the learned judicial magistrate which is suggested of exercise of excess of jurisdiction, or full stop. It cannot be also be said in the given facts of the present case that the given case of the present case that the learned magistrate has committed any material illegality. Full stop. In the considered opinion of this court, the magistrate was left with no option but to dismiss in view of the continuous failure on the part of the complainant to proceed prosecute his case and to bring witnesses on his record. And therefore, this court is not inclined to interfere with the aforesaid order passed, the impugn order passed by the learned magistrate in exercise of this court's revisional power. Accordingly, the criminal petition stands dismissed. LCR be returned back.
Deeply obliged.
PPSM. Yes. List is over. Yes, it is.
Matter may be taken on tomorrow, Lordship.
Here I have also gone through the record, my lord. Here only the appellate court record is here, only judgment is there. Other trial court records are not available. Only in the appellate court also only judgment, appellate court judgment is available. The trial court record is not available. Witnesses of prosecution witnesses that are not available.
It was conviction and the cheating, 417.
417, my lord. 6 months.
At 2.
So other 2 matters already.
Huh? Who is your senior?
AM Borbhia.
Huh?
Mr. AM Borbhia.
Wait. See the Elshire. The present revision petition. No record was even called for.
Only appeal judgment.
Huh?
Judgment.
Yes,
part.
Babua.
My lord, in this case, my judgment is defective, my lord.
What defective judgment?
Because my lord, charge was framed.
Higher. Which one is more? Charge was framed under? Charge was framed under 493.
Yes, my
And
lord.
conviction under 417. What is the punishment prescribed under 493?
That was my lord, higher.
Huh?
Higher, my lord, that one, my lord.
493 relates to what offense?
4, my lord, 17 is cheating.
No, what is 493?
An offense relating to marriage.
What is the allegation? What is the punishment? 493.
Cohabitation caused by a man deceitfully inducing a belief of lawful marriage.
Okay, so what is the punishment?
Next to imprisonment either for which may extend to 10 years
Hmm.
and shall also be liable to fine.
And fine. And what is the 417 punishment?
Okay. Punishment for cheating. Whoever cheats shall be punished with
3 years.
imprisonment for a term which may extend to 1 year.
So,
Or with fine or both.
Some judgment, my lord.
what are the judgment?
Because my lord,
It says when it is a lesser
that should
and
be-
it is
yes, yes.
relatable. Offense must be relatable. So that you have a chance. Basic fundamental allegation is same.
Right.
One is marriage, one is cheating or promise to marry.
Marry, man.
So therefore 417 is come. That promise to marry is relatable to the offense of 493. So therefore there is no wrong if that is the only ground.
No, like this is one of the ground, my lord.
And what is the other ground?
Merit different, my lord, because in this.
No, we are not hearing it today because there is some difficulties. Please tell us. You have taken.
But prosecution has
Oh,
proved that.
judgment we know. What did the judgment say? When it is a lesser charge is.
My lord, this is my lord rejected. It is said that, my lord, this punishment should be, my lord, under same chapter.
That's true.
Yes,
That
sir.
is correct.
But this is different chapter, my lord. Different head.
Chapter is different, but there will be another angle. There is some judgment which
Because
says it is if charge is the allegation of offense is relatable.
Man.
Okay, 2.
Record has not come, my lord, and in.
Oh, revision why record is required.
Well,
Record does not even call for.
Not even confirmed.
No record is called for. Who has sent it? Because I will ask for an examination. I will ask for an inquiry. Why this record is called?
Yes, my lord, because, my lord, I have no also, my lord, in my file also, my lord, evidence is not there, my lord.
Why evidence is required? Evidence is in revision vision. Why? We cannot reappreciate evidence.
No.
My lord, whether necessary or not necessary, lord should consider.
No, first, no, not consider. First thing first. Your first ground we will examine. If your first ground you succeed, why should we go to the evidence? If you say that these are 2 chapters, it cannot be.
Yeah.
It cannot be. We'll acquit you. That's all. This is a legal issue.
My lord.
If thereafter you say that there is a perversity, because on merit you don't have any ground.
Merit, no.
On merit, no ground.
No ground.
So why should we go to the evidence?
Ground is also there, my lord.
Huh? At 2, come back at 2, we'll see.
Yes, my lord, I have any other day, my lord,
I
Friday.
will wait. You complete your matras and come back.
Thursday, my lord.
See, at one, I have no work. Mr. Bhattakur, what to be done? You are happy in this bench.
Another.
Better to be here. Ah.
Suddenly has come, my lord.
Don't say that. Cases will come suddenly
Yes,
only.
my lord.
For judge also for lawyer,
Yes,
not
sir.
suddenly.
Definitely.
It was notified on Friday.
Yes, definitely.
Friday. Yes, Mahajan.
Can I take a photograph of the 161 of the victim, my lord?
Don't take photograph.
Photograph, no, no, no.
Don't take photograph. Write it down. How many?
Bengali does. Bengali.
Okay, we'll see. We'll see. We'll see. We'll read together. Musumi? No, no. These are small matters. It will take 5 minutes. If he is, he can satisfy, yes, that I also understand. But if it is in different chapter, it cannot be because it should be subject matter should be same.
Yeah, fine. In
Suppose
detail.
offense against body, these, there's all those chapters are there. There are some judgments.
Yes, my lord. I was there was a detailed judgment, my lord, referring Supreme
Give us the judgment. Tomorrow?
Tomorrow, my lord.
Tomorrow. List this matter tomorrow for hearing.
It is, my lord, criminal appeal, my lord, 216, 2000.
Give it to him so that he can
Well,
download from our high court.
Yes, yes.
By my lord, just
Ah, yeah, good, my
who's judgment?
lord. Well, this is Justice, my lord, S.C. Das.
And then there are some Supreme Court judgments.
Yeah,
Clear.
Supreme Court judgment referred, my lord.
Okay.
Many Supreme Court judgment referred.
Okay. What was the explanation given by the magistrate? Lesser only to the that since the SARS offense SARS was of having.
He said anything. He just, my lord, it is ultimately punished, my lord.
Appellate court also availed the method.
No, that's why. No, appellate courts. This concurrent findings we can interpret when is a glaring legal issues.
Right.
No problem on that. Okay, tomorrow. This matter tomorrow. Good. Some meetings with.
My lord, this case,
Ah.
It was initially by Mr.
Ah,
Dilip
Mr.
Mazumdar. I called him
Ah.
before accepting the brief. I said, why you are not appearing in this? He said, no, I had a
He
discussion.
told that he already have some
So whether
consultation.
I should take the case? He said, no, you can take the case. Normally, I have called my colleague for what reason. Now, my lord, I have seen it's a big case which has been filed. There was some order that was passed by this court. We filed an application for extension of time.
Extension
And
are granted.
Your lordship was kind enough to grant extension of time. As I have appeared, only one prayer is there for your lordship, that if it is not inconvenient to your lordship and a learned friend who is appearing for the election petition case. So at least a time if it is granted.
So
One
time
more
will grant objection filed.
My lord, I have filed my,
Yes, they have
I have
filed.
filed my return statement.
My lord,
If my learned senior is asking for some time, my lord, if
No,
it
that is not an
possible,
issue. I know that you will not object to that.
there is a petition which has been
20
filed by us.
For
20 of
that
November.
dismissal of that, the
Yes.
order
86.
under that act.
Yes, under
So
it.
they have filed also objection.
So we'll
So
look
give
in-
a propose that we'll fix it for hearing on that application on that day.
Yes.
And till then we'll
Yes,
extend that
correct.
earlier.
Correct,
This
correct.
is
That-
the order
that's-
will
that-
pass.
yes.
Now give a date.
20th November, if my learned senior agrees with
When
me.
when?
20 November,
20
20th
November.
November.
Only one inconvenience is there. If it is not
my lord said-
inconvenient to your lordship and my learned friend, can be thereafter.
Give a date. You propose a date.
22nd possible? It is a Friday. I don't know whether it is possible.
Not possible.
22nd.
22nd, Mr. Singh.
22nd, my lord.
Yes.
22nd or 27? 22nd.
22nd is a Friday.
Friday.
22nd might
No,
have been some
21st.
difficulty.
Or my lord, it can be 21st, Thursday.
21st.
20, 19. 21st is okay.
Okay. You write it down in
21st is okay.
in IA.
Number which
My lord, that will be 198.
Because what we have done, we have filed a new application. Although in that application, your lordship is allowed for extension of time.
Okay, file a fresh application.
I have filed a fresh
Okay,
application. Because
abandon,
yes, because these are very technical.
Of course, for a further
Entire,
extension.
entire. That's
Yes.
why you have to be very careful.
In IA 197 AP 2024. Okay, just write it down. The present application is filed for deferring filing of written statement by the sole respondent in the connected election petition for the reason that already an application has been filed by the respondent under section 86 of the Representation of Peoples Act 1951, challenging the maintainability of the connected election petition, which is registered as IAC number 198 within bracket AP/2024. This court, under its order dated 23/10/2004 to 2024, considering the aforesaid factual position, provided that till 11th of November till today, the filing of written statement was deferred. In the aforesaid, just write it, just delete the last line. In the aforesaid backdrop, this court, under its order dated 23/10/2024, provided that till 11th of November 2024, the filing of written statement by the sole respondent stands deferred. Full stop. In the meantime, an objection has already been filed in the aforesaid IAC number 198 AP/2024. Full stop. In a separate order passed in IAC number 198 AP 2024, this court has fixed the aforesaid IA for final disposal on 21st of November 2024. In view of the aforesaid, the present IA stands closed by providing that till disposal of the connected IAC number 198 AP 2024, the time for filing written statement stands extended. Okay. This is disposed.
My lord, this has been registered. New case has been
And
registered.
I'm coming to that.
Yes.
New case, now you write an order on IAC 179 AP. Isn't that it?
It's a 210 of 2024, a new IA which has been
Where is
filed
that?
for filing, because we filed there.
No, no,
Today.
that is here. That is not 219. It is IA 179.
No, there is a express application
Fresh
which has
application.
been filed
And what
today.
what is 179?
179. I think they have filed.
This is. I have passed the order in which now I have passed this. This is the you have filed extension
I know,
179
but
AP.
what has happened? Extension was granted to file WS. Now that was allowed.
Huh.
Today what we have done, we have filed a fresh IA for extension of time. That is,
Just give the
no,
give the IA.
This was registered today in the morning. I don't know whether it is transmitted or not.
No,
IA
see,
210.
one is application is 197.
Please look this, my lord.
197 is
210, Adi.
no. There is some confusion. Let me clarify it. So first application filed and registered was 197 AP 2024.
That is, we filed to defer it for filing
So
of
in
WS.
that I have passed the
No,
earlier
no,
order
yes, earlier
and
order.
today I have disposed it of.
Yes, correct.
Giving time.
Yes.
Okay, fine. Just listen to me. We'll come to your 210 later on. There is another IA in the file which was filed
179 of 2024.
179 of
This
24.
is, I don't know, because this is not, I have asked my learned friend. I think he will be able to say.
Yes,
this is
same petition. Why?
Pune file bolte
Application praying for 4 weeks time to file reply to election
No, that
petition
is
1
also
of
for extension
2020.
of time. That is also for extension of time to file WS.
Same.
Because I was.
In view of the order
Three
passed
IAs
in.
are all same.
Is not it? This is same thing.
Yes.
My lord, it is the same IA, my lord.
In view of the order passed in IA number 198 AP 2024, no separate order need be passed in this IA accordingly. Same stands closed.
Yes, 197.
Now
In
I am
view of-
coming.
No, your lordship has given in view of the order dated, so in IA number 198, it is not 190, 197.
No, 197.
197.
In view of the order passed in 197 AP 2024, will close the present IA being IAC number 179 within bracket AP 2024 stands closed.
Yes. Right.
Okay.
Yes.
Now, have a talk with them. We'll pass a similar order closing this.
Yes, because 210, we file it because your lordship 197,
It
your
was
lordship has deferred it with the filing of WS.
till 11th.
That's why I
So
thought
you have
that-
filed fresh access.
Fresh access.
Therefore, I have extended till disposal.
Yes, correct.
And now in view of order passing, they will send it. Na? You have a Xerox copy, they will just have a talk with them to registry. In view of order passed in
197.
197 AP 197 2024, no separate order is required to be passed in this IA. Accordingly, same stands closed.
We have prayed for 30 days time to file this WS in this 210.
No, that we have already deferred
Yes,
till
yes.
disposal.
Then
You
it's okay, then
you,
fine.
you file an application on the delivery of the judgment
Yes, exactly.
on that day.
Yes.
Then we'll
Because
see.
I have seen.
Or in fact, that we can give on our own since this is pending.
Yes.
We can give 30
Then
days time.
Absolutely no problem.
Yes. So we have closed this.
Yes. Because we have what we have done in IA, this 210 of 2024, which we have filed, seeking extension of time to file a WS without prejudice to our right to file any other application. That's we have made. Without prejudice to file any other application.
Then you may file order 7 rule 11.
That's right.
We
That's
know
right.
that. We know that.
So I have written in that without prejudice.
Of course.
Yes.
That application is of course.
Okay.
Then if you file on that, we will give a time to 30 days.
Correct.
Whatever way. If we dismiss your petition,
yes,
then you will have a chance to file written statement or whatsoever you file.
Yes, correct.
That is one. That right will not take away.
Yes.
Second thing, if it is your petition is allowed, matter ends there.
Yes.
That is to be decided
Yes,
by
yes.
in the upstairs. Isn't it?
I'm deeply obliged. Sir.
Yes. Yes, next case. One order dilu, no? Oh, one election petition, na? No, it will take over. List this matter. Just it, no. The parties, the respondent election petitioner has already filed their objection in this IA. Full stop. Full stop. As agreed to by the learned counsel for the parties, list this matter on 21st of November 2020, 21st of November 2024 for final disposal. Mr. Singh, be ready on that day.
Obliged, my lord.
Yes.
I'll
Just we are issuing a notice to you. If you want to respond. Mr. Ratan.
My lord, we have filed our affidavit, my lord.
Affidavit you have already filed.
Yes, my lord. Stating that we also agree for tripartite.
No, your agree and disagree will not be cannot be a ground for review. So, and another question will be whether review to what extent in arbitration. Yes, Mr. Seshadri, be ready. You people have waited for so many time. We are fixing in the month of January.
In the month of January?
Yes.
Would your lordship consider a short?
May I only
make only one submission, my lord, only one small submission. They have no objection, my lords. We're only requesting that Justice Sarma be appointed on behalf of the respondent, my lord, because I have already appointed Justice Sikri. In fact, my
so
learned...
they are also accepting your same proposal.
Yes, my lord, they're agreeing to that, my lord. And let Justice Sikri and Justice Sarma appoint the presiding arbitrator. That is only request, my lord.
My lord, we are proposing for Justice Indu Malhotra in our affidavit.
Okay, we'll hear this matter. Give a date.
Your lordship, give it to any short date, my lord, subject to your
Any
lordship.
short date, any short date. Should we give a date? Second half at 2. Some date. Not 21st, thereafter. Twenty-eight is it? Mr. Seshadri, we'll take up this matter on 28th of this month, November.
Yes.
Tentatively after I finish the list, okay?
My lord,
Yes, my lord.
my lord, can it be on some other day instead of 28, my lord? 28, I will have some.
Okay, propose a date around those days.
25th, subject to your lordship's convenience.
When 20?
25. November.
25?
25 is a holiday here, November.
Yes.
It's a holiday. Holiday.
26.
26, then on 26.
Miscellaneous date.
Then 28th is fine with me, my lord. 29th is also fine.
29th, Mr. Ratan?
But I will have some difficulties on 28 and 29, that's why.
29, 38?
30th is a
Saturday,
Saturday.
then 2nd of December.
2nd is fine.
2nd of December.
Fine.
Yes, ma'am.
But tentatively, you have an idea that we will take up your matter at the bottom of the list.
Yes, my lord.
Okay. So that I can hear and understand.
Yes.
Okay.
Very well.
Obliged, ma'am.
Mr. Seshadri, just enlighten me on the in such a petition, the review, power of review.
Yes, my lord. We are only seeking. Yes, my lord. We are only seeking review.
That is the point. If you can give a handle, if both party agrees, I am expressing my tentative view, that then I'll agree.
Grateful,
But
ma'am.
only thing is that order is to be passed having jurisdiction.
Yes, ma'am.
In a case where I can exercise my review jurisdiction.
Yes, ma'am. I'll give some judgments.
That give us the handle, I'll agree.
Yes, I'm grateful, ma'am. I will do that. I
Just
will.
give that handle. Lot on you also to look into.
Yes,
But
ma'am.
you have agreed, so I can reopen these things once again in review, once after appointing an arbitrator.
Yes, ma'am.
Or
Yes, ma'am.
that is handle you give me.
Yes.
Yes.
My power. That's all.
Grateful.
There's no express provision for review and all, but of course.
I'm grateful. I'm grateful. I will. You will get some.
Obliged, ma'am.
Grateful.
That's all.
Great.